Okay, we'll just wait a few moments as people make their way into the webinar. Okay. So good afternoon, everyone, and welcome to our third webinar in the Trademarks in Canada series. My name is Graham Hood, and I'm a partner in the Trademarks Practice Group at Smart & Biggar. Today, I'm joined by my colleague, Quan Lo, and we will be speaking to you for today's presentation on Canadian and U.S. trademark prosecution, northern highlights, and key differences that brand owners and their counsel should know. So before we begin, I'd like to start off with just a few housekeeping matters. Over the next 40 minutes or so, we'll take a look at those important differences between trademark prosecution on either side of the 49th parallel and discuss best practices and key strategies for protecting your or your client's brands. After that, we'll take questions from the audience. You're welcome to submit your questions at any time during the presentation. You can type them into the Q&A panel, which can be accessed by clicking the Q&A button at the bottom of your screen. But please do not type any questions into the chat panel. And we'll try to address as many of your questions as we can during our live session or in a follow-up email after today's webinar. Today's webinar will be recorded, and following the presentation, we'll circulate an email with a replay link together with a PDF copy of the slides from the presentation. So as I mentioned at the outset, my name is Graham Hood. I'm a partner with the firm's Trademarks Group in Toronto. My practice really spans all aspects of trademark counseling, prosecution, enforcement, and litigation, with a heavy emphasis on serving US-based clients. It also includes a significant anti-counterfeiting component as well. Quan?
Thank you, Graham. Hi, everyone. My name is Quan Lo, and I'm counsel in our firm's Vancouver office. My practice is almost exclusively focused on trademarks, including all aspects of the trademark lifecycle, from clearance and searching to prosecution to enforcement and litigation. The core of my practice is really being a brand strategist and working with clients to select, build up, and protect their brands in Canada, and in some cases in the US and around the world. Thanks, Graham.
So Smart & Biggar is Canada's leading IP law firm. Our expertise spans all areas of IP. It's deeply rooted in over a century of serving clients. We have 5 offices in major city centers across the country and more than 100 lawyers, agents, and technical consultants. Our firm handles over 8,000 patents and trademarks every year and boasts an unparalleled litigation bench strength and record of success. With that, we'll turn it over to Quan for an overview of today's webinar.
Thanks again, Graham. Today, we will identify some of the key differences between trademark prosecution in Canada as compared to the United States. While there are more similarities than differences, it is important to understand those differences and the impact they can have on the rights of brand owners in Canada. Our presentation today will cover 6 areas: filing applications, prosecuting applications, international compliance, proceedings before the Trademark Opposition Board in Canada and the Trademark Trial and Appeal Board in the US, registrations, and a miscellaneous point. We will then wrap things up with some key takeaways, and then, as Graham has mentioned, we will end with a question and answer period. So I will lead us off today by discussing some of the differences between filing trademark applications in Canada and the US. Following the changes to our trademark law, which came into force in June 2019, Canadian applications no longer require a filing basis. As some of you know, This brings Canadian practice into line with the practice of many other countries, but it does bring us further away from the United States, where a filing basis must be provided. Additionally, there is no longer a need for a trademark to be used in Canada or anywhere else in the world prior to registration. We have done away with our old declaration of use practice, as some of you may remember from before 2019. And unlike the US, we never had and still do not have a requirement to provide a specimen of use of the mark. All of that having been said, the concept of use remains fundamental to our trademark law, and a senior user will enjoy an advantage when it comes to oppositions and enforcement of trademark rights in this country. However, because use is not required to file an application or obtain a registration, the mantra of filing as soon as possible is perhaps even more important than it used to be under the old law. I will now turn it over to Graham to discuss some differences in prosecution.
Thanks, Juan. So one key difference in prosecuting applications in Canada, unlike in the US, there's no supplemental register. What this means is Canada has only a single register, the equivalent of the US principal register. And so in cases where a mark is met with a descriptiveness objection or a distinctiveness objection that cannot be registered until it's acquired a certain level of distinctiveness, there's no place to park your mark until you acquire that requisite secondary meaning. So when faced with such objections, you can either submit written arguments to overcome the objections or evidence of acquired distinctiveness. There's really no other option. Similarly, there are no state or provincial registrations. Canada maintains a single federal register of trademarks. And as we'll see later on in the webinar, in certain circumstances, some registrations may be limited to a specific geographic region. For example, where registrations for inherently non-distinctive marks can only demonstrate the requisite secondary meaning within a certain geographic region, marks are otherwise entitled to national protection once registered on our federal register. Another key difference, and one that comes up seemingly daily in my practice, is consent agreements. There's a big difference in the way CIPO and the USPTO treat consent agreements. If the Canadian Trademarks Office concludes that there's a risk of confusion among consumers and issues a confusion objection, notwithstanding an agreement between the parties, a letter of consent, settlement agreement, coexistence agreement, what have you, it will maintain the objection to fulfill its role of public protection. The consent of the owner of a cited mark will not suffice to overcome the objection. It will be considered. The Trademarks Office will take a look at it, but it will be afforded very little weight. The Trademarks Office takes the position that it is the guardian of Canadian consumers, and as a result, it shouldn't matter whether brand owners believe that confusion is unlikely. Ironically, the Trademarks Examination Manual includes certain elements, certain provisions that ought to be included in a letter of consent or a coexistence agreement, even though CIPO and its examiners afford such agreements very little weight. There's also the matter of disclaimers. The Canadian Trademarks Office, for a time, routinely required applicants to disclaim the right to the exclusive use of any portion of a trademark that was not independently registrable due to descriptiveness, for example. However, in 2007, the Trademarks Office disposed of disclaimer requirements. Disclaimer requirements cannot be used to overcome descriptiveness objections, distinctiveness objections, or even confusion objections. And while an applicant may voluntarily enter a disclaimer, such disclaimers are fairly uncommon and of very limited value. With that, I'll turn it back to you, Kwan.
Thanks, Graham. So the first point on this slide is another change following the amendments to our trademark law in 2019. Examiners can now issue an office action with an objection that the trademark is not inherently distinctive. This objection may be issued in conjunction with the descriptiveness or surname objection, and we see that quite often. Or it may stand alone where the mark is not descriptive, but the examiner is nevertheless of the view that the mark lacks inherent distinctiveness. For example, that a mark is laudatory or entirely generic based on the examiner's research. It is possible to overcome these objections by filing written arguments or evidence of acquired distinctiveness or secondary meaning as established as of the filing date of the application. I do note that the bar when it comes to establishing secondary meaning is relatively high in Canada. I also note that the practice has been changing somewhat with respect to these not inherently distinctive objections. Examiners seem to be doing a better job of more carefully considering whether an objection should be issued. And we appreciate that in some cases, the mark is borderline descriptive. It's very suggestive, and the examiners sometimes struggle in considering whether or not they should issue an objection for the mark lacking inherent distinctiveness. But we find that from recent experience, they're really thinking this through and I think getting more experience at determining whether an objection should be issued or not. We're also finding that they are more receptive to written arguments in cases where they have issued the objection. We are keeping our fingers crossed that the practice will remain reasonable when it comes to these objections. I'll be very brief on the second point on this slide. Starting last year, Canadian practice now provides for certain minor issues to be addressed over the telephone with an examiner, such as minor amendments to the identification of goods and services, classification issues, or typographical issues. An important difference between the Canadian and U.S. practice when it comes to telephone amendments is that in Canada, it is still necessary for the agent to prepare and file an amended application that includes the changes requested by the examiner. The examiner will not make the amendment themselves. It remains to be seen whether this initiative will end up covering other types of objections and issues. But in the meantime, it is a welcome change as the Trademarks Office attempts to improve the efficiency of trademark prosecution in Canada. Which brings me to the next point on the following slide. So I've heard from some of you that prosecution in the United States is not nearly as quick as it used to be, with turnaround times of about 6 to 8 months from filing to examination. Well, just wait until you hear this. In Canada, the current turnaround time from filing to examination is almost 3 years. I'm just going to let that sink in for a moment. That's right. It takes 3 years from filing to getting a first office action or an approval notice. And unfortunately, that is unlikely to change in the near future as the office remains in catch-up mode and the number of applications being filed in Canada is not slowing down. However, the office has been hiring and training new examiners and also implementing new initiatives such as the telephone amendment initiative I just mentioned, with the view to try and reduce the delays in prosecution. Finally, the last point I'll make here relates to extensions of time in prosecution. Prior to this year, it was possible to request an automatic 6-month extension to respond to any office action, even if the objections related to non-substantive issues. Starting this year, that automatic extension is no longer available, and a single 6-month extension will only be granted if one or more substantive objections are raised. However, extensions do continue to be available where there are exceptional circumstances, such as where the applicant has initiated an opposition or a cancellation proceeding against the cited mark. I will now briefly highlight some of the issues pertaining to Madrid filings and NIS classification. As many of you know, Canada only joined the Madrid Protocol and implemented NIS classification in 2019 with the changes to our law. With respect to Madrid Protocol applications, CIPO has taken the position that it will not deposit all correspondence with WIPO, and it will not forward correspondence to a foreign representative acting for the applicant. Instead, after issuing an initial courtesy notice, correspondence from CIPO will only be sent directly to the applicant or an appointed Canadian agent. As a result, to ensure that no correspondence is being missed, and given that extensions of time are no longer as readily available in prosecution as before, we highly recommend that applicants have a Canadian agent appointed early in the application process. Turning to NIS classification, the only point I wanted to make here is that Canadian practice requires applicants to be very specific when identifying the goods and services set out in an application, and in many cases, language that is considered acceptable by the USPTO will not be accepted by CIPO. Now, there is a Canadian Goods and Services Manual available online, which includes examples of language that will certainly be accepted by CIPO. But the breadth of the goods and services covered in the manual remains relatively limited, although it has improved over the years, and CIPO has been updating the manual from time to time. With that, Graham will now discuss some of the differences arising in opposition and cancellation practice.
Thank you very much, Kwan. So there are a few key differences to bear in mind when appearing before the TMOB in Canada or the TTAB in the US. We'll talk first about opposition procedures, and then a few brief comments on cancel culture, cancellation proceedings in the two countries. So with respect to opposition proceedings in Canada, they're relatively simple, relatively straightforward. They're a summary proceeding, and they tend to be less expensive than the more complex procedures that take place in the US. There are a number of steps involved in a Canadian opposition proceeding, just like in a US proceeding. However, in Canada, many of those steps are optional. There is a pleading stage where the opponent files its statement of opposition, setting out the grounds of opposition. And the statement of opposition itself is really a pro forma complaint. The applicant then has an opportunity to file a counterstatement, essentially an answer, summary denial of the allegations set out in the statement of opposition. With the coming into force of the Trademarks Act in June of 2019, that procedure has actually been simplified further. Now, an applicant need only state with a single sentence that it intends to defend the opposition. Then, once pleadings are closed, the parties move on to an evidentiary stage. The opponent files its evidence. The applicant then has an opportunity to cross-examine on that evidence before filing its own, and then the opponent has an opportunity to cross-examine on that evidence before filing any evidence in reply. This stage is also optional. Theoretically, an opposition proceeding can make its way to a hearing without any evidence having been filed by either party. And the cross-examinations on the affidavits filed are typically narrow in scope. There is no wide-ranging discovery. Questions are restricted to the four corners of the affidavit, as well as any issues that may be have arisen between the parties in the course of the opposition. So the deposition process is considerably more restricted in Canada, and as a result, the evidentiary stage can be over and done with quite quickly. The parties then move on to an argument stage. And again, up until June of 2019, before the coming into force of the new Trademarks Act, it was practice that both parties would file their arguments simultaneously. And it often led to a matter of anticipating what the other party was going to say and filing your arguments in respect of those comments at the exact same time. Now it's one step at a time. The opponent has an opportunity to file its written arguments, and then the applicant answers with its own. Again, this stage is optional. The parties do not need to file any written arguments if they do not wish to do so. Then after that, once the arguments are in, the parties have an opportunity to request an oral hearing before the board itself. Again, this is optional, and this is in fact the longest stage of the opposition proceeding in Canada, simply because it takes forever to get a hearing date. In some cases, it can take upwards of 2 years before the opposition board gets back to you with a hearing date. Following COVID, most, if not all of these hearings are now being held via Zoom. The opposition board has no intention of resuming in-person hearings anytime soon. So if you wish to appear before the board, chances are you will appear via Zoom. You can, of course, appear by phone if you prefer, but Zoom is now standard practice. All things considered, an opposition proceeding will typically take anywhere from 2 to 4 years, depending on the steps taken by the parties. And as I said, the longest stretch of time is simply waiting for your hearing date. They're also relatively inexpensive compared to the bills that one can accrue in the US before the TTAB. In Canada, you could probably complete an opposition proceeding, having taken every step along the way, for under $100,000 or so. Unfortunately, as of now, the registrar or hearing officer does not have any jurisdiction to issue costs awards. However, that is something that will be changing. We're currently awaiting on the trademark regulations that would put those powers into place. And when those new powers come into place, I imagine it will change the incentives for many parties to oppose applications. And then there's the matter of cancellation proceedings. So currently things are a bit different as between the two, and the Trademark Modernization Act, which has been introduced and will be coming into force later this year, will change things a bit and bring the US cancellation proceedings somewhat in line with those in Canada. At present, only a party that may be damaged by another's registration may seek cancellation of a registration in an inter-parties proceeding before the TTAB on the basis that the mark has been abandoned without an intent to resume use. Now, once the regulations implementing the TMA are established, those cancellation proceedings will change somewhat. We'll see the introduction rather of ex parte re-examination, as well as ex parte expungement. Now, in Canada, we really only have one cancellation procedure, and it is effectively inter partes, but as I'll explain, the requesting party or petitioner, as it's called, really has an opportunity to request the evidence of use and pull away from the proceeding. It doesn't need to file any evidence of its own. It doesn't need to file written arguments if it doesn't wish to do so, and it doesn't need to appear at an oral hearing if it doesn't wish to do so. So a cancellation proceeding is really a one-sided affair in Canada. The requesting party puts in the letter or petition, and then suddenly the onus is on the registrant and remains on the registrant throughout the entire proceeding. In the U.S., with the TMA coming into force, we'll have ex parte re-examination available within 5 years of registration. It's unique to the U.S. There's no equivalent procedure in Canada. And in that, any person can file a petition for re-exam on the basis that the mark was not used in U.S. commerce in connection with some or all of the goods and services as of filing date for use-based applications, or the date on which the statement of use was filed for ITU applications. With ex parte expungement, we have an opportunity to challenge a registration between 3 and 10 years of registration. It's similar to, but different from, Canadian cancellation proceedings in certain important respects. Like in Canada, any person can file a petition, but unlike in Canada, that person must demonstrate that a reasonable investigation was conducted and provide facts and supporting evidence to the USPTO to suggest that the registrant has in fact not used the mark in connection with certain goods and services. As I mentioned, in Canada, all that's required is a simple letter from the requesting party putting in place the cancellation proceedings. In both Canada and the US, the registrar or the director of the USPTO, as the case may be, has the initiative to commence these proceedings by themselves. They don't necessarily need to wait for a request from a requesting party or a petitioner. So similarly, in both jurisdictions as well, the decision, however rendered, is appealable to the court, and the specific rules for the TMA are expected to be finalized no later than December of this year. So a few things to consider. It appears that in the USPTO, certainly by the end of the year, there will be more tools available to clear the register of dead wood. In Canada, the process is very summary in nature, very one-sided, and in fact can be used to one's advantage when concurrent litigation or opposition proceedings are ongoing and a party is looking to increase its leverage in those proceedings or in settlement negotiations. The cancellation proceeding in Canada is really a one-sided affair and costs the registrant a lot of time, money, and effort in demonstrating that it has in fact used its mark in Canada within the relevant period. So with that, I'll turn it back to Kwan. Who is it? Actually, it's me. I'm still here. Okay, moving on to registrations. So a few comments about registrations. In Canada, a registration affords its owner nationwide protection. Unless it is geographically restricted, a Canadian trademark registration gives its owner protection in every province and territory across the country. It can be secured even where there is no interprovincial or international trade or use. As Kwan mentioned at the outset of the webinar, as of June 2019, it's no longer necessary to claim use, to demonstrate use in order to obtain a registration in Canada. There are also a few side benefits to obtaining a registration in Canada. For one thing, it satisfies Canadian presence requirements under the CDRP to register a .ca domain name. So if you're a foreign applicant, you're looking to register a .ca domain name that includes the registered trademark, well, you can register that mark, and that registration will satisfy the presence requirements, allowing you to register that .ca domain name. You can also record your rights with the CBSA, Canada Border Services Agency. This is the customs officials that monitor incoming and outgoing commercial shipments. If you have a registered mark in Canada, you can register or record that mark with the CBSA, and that will put the CBSA on notice to look out for any suspect counterfeit or pirated goods that may bear the mark or a confusingly similar mark. And it also allows rights owners to obtain nationwide injunctions. Even if a rights owner is not using its registered mark in a particular area of the country, it can rely on its registration to obtain nationwide injunctions and take action against infringers in every corner of the country. There's also a very straightforward renewal procedure in Canada. Renewal is a relatively simple process. A trademark owner can maintain a registration simply by paying renewal fees every 10 years. There's no maintenance fees, no specimens of use to be filed. All that's required is the renewal fee every 10 years. In fact, only if a registration is attacked in the course of a cancellation proceeding, as we discussed earlier, would it be necessary to demonstrate use and file specimens of use with the Trademarks Office. And with that, I will now turn it over to my colleague Kwan. Thank you.
Thanks, Graham. So shrouded behind the mystery of this miscellaneous slide here is the final difference we wanted to highlight today, and it relates to a very unique aspect of Canadian trademark law that I haven't seen in any other jurisdiction. As some of you may have encountered in the past, in Canada, we have what we call prohibited marks, more well known as official marks. These marks, which are available only to universities, including U.S. universities, and Canadian public authorities, can be very useful and powerful for the following reasons. First, these official marks are not limited to specific goods or services. There's no ability to cover goods or services, and in fact, they cover all goods and services, all 45 classes under the NIS classification, meaning they're not limited to a specific field of trade. Second, these marks are examined only for formal requirements, meaning prosecution often only takes about 4 to 6 months, sometimes even less, which is far less than the 3 years we're seeing these days for regular trademark applications. Third, official marks can be all the things that make a regular trademark unregisterable. They can be confusing with a regular trademark or resemble another official mark. They can be descriptive. They can lack inherent distinctiveness. They can be geographic terms. They can be a surname. Once entered on the register, these official marks can form the basis of an objection against a later filed regular trademark application if the marks are identical or highly similar. And in many cases, the only way to overcome that objection is to obtain the consent of the official mark owner. It is entirely at the discretion of the official mark owner whether they wish to consent or not. From experience, many entities are reasonable about providing consent, although I have also dealt with cases where consent has been unreasonably withheld. A common practice is for the owner of the official mark to ask for reimbursement of its legal costs in providing the consent and dealing with counsel. Now, in most cases, again, parties are reasonable and the requests for costs I've seen tend to be fair. But I will say that I have seen a couple of cases where it seems to me that the official mark owner is really taking advantage of their position and asking for an amount that seems to be far greater than reasonable legal costs and disbursements associated with providing consent. I should also point out that official mark owners can rely on those marks to oppose a regular trademark application for a similar mark, and that official marks can only be removed by way of an application brought before the Federal Court of Canada, unless the owner of the official mark voluntarily withdraws it at the Trademarks Office. So for all of these reasons, holders of official marks can wield significant power and influence over a party's ability to register a regular trademark in Canada. And so with that, Graham will now take us to some of the key takeaways from our presentation today.
Great. Thank you, Kwan. So a few key takeaways to take with you with respect to contentious issues in Canada. One, we mentioned earlier, worldwide coexistence and settlement agreements are a key aspect of overcoming objections in the U.S. and in Canada. They don't work all that well, quite frankly, in order to overcome a confusion objection. So it's important not to assume that a worldwide coexistence or settlement agreement will allow a client's application to register. There are certain things that ought to be included in those agreements, but quite frankly, the Trademarks Office in Canada affords them about as much weight as the paper on which they're printed. So something to bear in mind, a consent agreement is not a silver bullet in Canada. That said, it's important to consult with Canadian counsel regarding such agreements, because if you are using them, specific language should be included. It will increase the likelihood of acceptance by the Trademarks Office. As I mentioned, the Trademarks Office will take a look at them, but they will not suffice to overcome an objection. They're simply one further thing to be thrown into the hopper, something to be considered when assessing the likelihood of confusion between two or more marks. Also, be sure to take advantage of non-use cancellation proceedings in Canada. If you come up against a cited mark that's been on the register for a long period of time, and a quick desktop search suggests that it's not in use in Canada or not in use in Canada with the particular goods and services set out in the registration, you may be able to challenge the mark, have it expunged from the register on the basis of non-use, and that will overcome the confusion objection raised by the examiner. As I mentioned, these proceedings are summary in nature. They don't cost the requesting party a whole lot of money, especially if the requesting party doesn't participate by filing arguments or doesn't participate in an oral hearing. It really is a one-sided affair and can be used to strategic advantage to overcome objections from the Trademarks Office in certain instances. And then there's the matter of prohibited marks. These are the official marks that Kwan was referring to. These are really a rather unusual creature of Canadian trademark law. And there are a few things to bear in mind when faced with an objection based on a prohibited mark. Well, first of all, the test under the Trademarks Act is a bit different. The test is not a confusing test. It's rather a more stringent, more narrow, so nearly resembling test. So if you find yourself faced with an objection, it would be in the examiner's view that the applied for trademark so nearly resembles as to be likely to be mistaken for the prohibited mark. And what that means is when assessing confusion, you really need only look at resemblance, appearance, sound, the ideas suggested by them. That's it. Goods and services don't matter. Channels of trade don't matter. It's really just the resemblance. So a few things to bear in mind. You can overcome such objections with written arguments saying that the marks are not so nearly resembling as to be mistaken for one another. You can overcome the objections with the written consent of the owner of the prohibited mark, which, as Kwan mentioned, can occasionally be withheld unreasonably. And you can also overcome the objections with evidence that the owner has been dissolved. Many of these prohibited marks, which remain on the register, are fossils. They are associated with government agencies or public authorities that are no longer, in fact, around today. So if you can demonstrate that they are no longer, in fact, around today, that may suffice to overcome the objection. With that, I'll turn it back to you, Kwan, for the remainder of our key takeaways.
Thank you, Graham. So my takeaways here, there are three of them, are pretty straightforward. First, with the delays in prosecution in Canada, planning ahead is perhaps more important than ever when dealing with the client's Canadian trademark rights and portfolio. Bearing in mind that use is not required to file or register a mark in Canada, it really behooves brand owners to act early when it comes to seeking registration in Canada. Second, appoint a Canadian agent. And I promise this will be our only sales pitch of the day, preferably smart and bigger, to handle your client's Madrid Protocol applications in Canada. We do not charge for appointing ourselves as agent, and there's really nothing to be gained by waiting for examination or an office action before having a Canadian agent appointed. Finally, and this point is directed primarily to our friends at U.S. firms in our audience today, you can expect that more of our Canadian clients and Canadian applicants in general will be looking to register marks in the U.S. based on use of the mark in your country, since waiting to rely on a foreign Canadian registration could, based on the current backlogs in Canada, set a U.S. application back by a few years. So that brings us to the conclusion of our presentation today, and so we will now turn to your questions.
Thanks, Juan. So go ahead.
Sorry. So the first question I have here is, does CIPO's refusal to send correspondence to WIPO and the agent of record in the WIPO record not violate the Madrid Protocol? That's an excellent question. And Graham, certainly feel free to chime in if you have any thoughts on this. My answer is, well, frankly, my answer is I don't know. My suspicion would be that in coming up with this practice, we would have looked at the Madrid Protocol, not we, but the Canadian government would have looked at the Madrid Protocol and ensured that there would be no issue in adopting this practice. However, I don't know personally, and I certainly haven't reviewed all of the ins and outs of the Madrid Protocol to know whether this would be a violation. My suspicion would be that it isn't, but I can't confirm that myself.
Yeah, it's an excellent question, and it is certainly unusual that in Canada, and only Canada, that CIPO will be writing only to the applicant or its Canadian agent if one is appointed. So I think CIPO probably gets around this issue because it's still forwarding correspondence to the applicant itself. But it is something that was really unexpected. It was not asked for by the Canadian IP bar. CIPO simply made the announcement, and suddenly, if you're filing Madrid Protocol applications and you don't have a Canadian agent appointed, well, CIPO won't be writing to you. CIPO will be writing directly to the applicant. So that's why it's critically important that those applicants appoint Canadian trademark agents to take their mail, to opine on it, and to help prosecute the applications to registration.
Yeah, very good points, Graham, and I fully agree. So to our next question then, do you foresee the Canadian practice to evolve to correspond with the US practice with respect to examiner amendments, trademark documents being available to view online, and examiner reports being sent via email? I'll hop onto this first, but Graham, feel free to jump in afterwards. I'll address first the point of trademark documents being available to view online. That's something that I know the Trademarks Office certainly wants to provide, and there have been discussions about it, but at this point, I feel like it's very much one step at a time when it comes to Canadian trademark prosecution. I think right now the focus is really on bringing down that delay at the Trademarks Office, and that just kind of overrides everything. But certainly the ability to view documents online is something that's very convenient when it comes to reviewing the records of the USPTO, and CIPO certainly knows that. They've discussed this internally. I don't think there are any plans at this point, any concrete plans to implement a website that will provide for documents to be viewable online, but it's certainly something that is in mind at CIPO, and something I imagine they'll want to implement, but at this point, I don't have any firm dates or any kind of runway with respect to online documents. As for examiner amendments and examiner reports being sent via email, I think those would be great things to have. And I think with respect to examiner amendments, CIPO is really looking at how these telephone amendments are working with respect to the initiative that we have now. I think about a year in now, I think things have gone well. They are allowing applications to move forward more quickly when the issue is something very simple, such as just an ID issue or classification issue. And so I think CIPO has seen that, and I think they will carefully consider whether to expand that practice to deal with other issues, and perhaps to allow examiners to make amendments if there's an agreement by the applicant or the agent over the phone, but that remains to be seen. And as for examiner reports being sent via email, that's not something I've heard about before. Again, I feel like with things moving more and more online, that is likely something that CIPO would consider going forward, but I certainly haven't heard anything to suggest that that would occur in the near future.
So I think the U.S. PTO can teach CIPO a lot of lessons about how to increase prosecution and examination speed. I think in the 21st century, you can't operate a trademarks office and not deliver examiners reports via email and not have an online repository of documents. I think it is only a matter of time. That said, as Quan mentioned, who knows when it's going to happen, but I think we will see a broadening of the scope of possible examiner amendments because the Trademarks Office knows that its wait times are embarrassing, and it is doing what it can to shorten those wait times. And I think we'll see more of these initiatives and in a move to an electronic service window that assists applicants and assists their counsel going forward. But I don't know when it's going to happen.
Agreed. Thanks, Graham. Again, really good points. The next question is actually two questions. Can prohibited marks be registered by universities outside of North America? That is, can foreign universities register prohibited marks in Canada? The answer, I believe, is yes, and I should have been more clear in my presentation. I referred to including U.S. universities, but of course that also applies to foreign universities. The definition, when you're looking at the section of the Trademarks Act that deals with prohibited marks, there's a reference to universities, but there's no reference to Canadian universities. And certainly we know that U.S. universities have registered official marks in Canada. I don't think I've personally come across a non-U.S., non-Canadian university having registered an official mark, but to my knowledge, there's no prohibition on that, and they should be able to obtain a prohibited mark. I do know that with respect to public authorities, the law has said that those must be Canadian public authorities, so we do have law confirming that point, but to my knowledge, there's no equivalent limitation when it comes to universities, and I see no reason why a foreign university outside of Canada and outside of the US couldn't register a prohibited mark in Canada.
That's exactly right, Quan. It's any and all universities. That being said, I have had the unusual experience of being asked to demonstrate how the applicant is a university. So submitting evidence of the underlying enabling legislation, for example. That was an odd request. It doesn't happen very often, but it's something worth having in your back pocket in the event that the examiner does ask for proof that the applicant is in fact an operating university.
Great, thanks, Graham. And in fact, I just see that in our chat box, someone has kindly advised us that the answer is yes to universities outside Canada and the US, with an example of the University of Reading in the United Kingdom. So thank you for helping us with that question. The next question I have here is a request to say a few words about letters of protest in the two jurisdictions. That's a really good question, really good point. I don't mean to put you on the spot, Graham, but do you want to take this one first?
Sure.
Okay.
So I know with the coming into force of the Trademark Modernization Act at the end of the year, letters of protest, I guess that ability to file letters of protest will be expanded in the U.S. In Canada, with the coming into force of the new Trademarks Act in June of 2019, letters of protest are permitted, however, on very narrow bases. For example, the Trademarks Office will not accept written argument from a third party. Really, it's a one-liner letter saying, take a look at this application on the register, or take a look at my client's pre-existing registration. I understand that in the U.S., once the TMA comes into force, a third party may be able to file actual evidence in protest, and that is something that is not available to brand owners in Canada at this time.
Thanks, Graham. That's right. I've looked into this before. I haven't been asked to file a letter of protest in Canada, but I've certainly been asked to look into this. And that's right. You can only make very brief submissions. It would amount to something like 3 sentences. And that's it. You file the submission and then you wait and see how CIPO responds to it. They don't report back to you. They don't let you know how they handled it. You just wait and see whether an office action issues or what happens. So the next question I have here is, why wouldn't Canadian companies file in the US on the intent to use basis rather than the basis of actual use in the US? That's a good point. I forgive me if I'm not totally understanding the question, but certainly if a Canadian company wants to file in the US and they haven't used the mark in the US, then they could definitely proceed on an intent to use basis. If they've used the mark in the US, then of course they can proceed on the basis of actual use. If this question is being asked following my comments about delay in prosecution, the point I was trying to make there is that in the past, and what still happens is that Canadian applicants will often file into the United States on the basis of either intent to use or actual use, but there will also be a separate filing basis based on foreign use and registration of the mark. And so what happens now is that because Canadian prosecution is so backlogged, what I've seen quite frequently actually is that an office action will issue in the US and the issues will be addressed, and then the application will be placed into suspension and have to be suspended multiple times because nothing is happening in Canada while we wait for the perfection of the foreign registration basis. And what we're seeing more often these days is that Canadian companies are saying, well, we don't want to wait 2.5 years or longer, even in some cases, for a Canadian registration to issue. We're going to actually just proceed only on the use basis, whether it's proposed use or actual use in the US, and even do away with the other filing basis, which was foreign registration of the mark. So that was the point I was trying to make there, and I hope I've answered the question here. The next question I have is a very good one. How are you dealing with managing client expectations with respect to examination times? So in some cases, we beg and we grovel and we ask for forgiveness. But jokes aside, clients, I think, have been quite reasonable. What we really try to do is we set this out beforehand. When I speak to clients, when I'm corresponding with them, we let them know, here is the expected examination time. This is how long it's going to take. It does come as a surprise. As Graham mentioned, it is quite embarrassing for us to have to say that it takes this long. But unfortunately, there really isn't much we can do in most cases. Now, I will mention briefly, and Graham, feel free to jump in on this point. One difference that has come about recently is there's now an ability to request expedited examination. And that's particularly relevant when there is online counterfeiting or expected counterfeiting or knocking off of a client's goods or services. And by swearing an affidavit and providing that to the Trademarks Office, there is now the ability to request expedited examination. And I believe it was just shared with us yesterday that in some cases that expedited examination could result in the issuance or the moving forward of an application, such as issuance of an office action, within a couple of days of the materials being received and reviewed by CIPO. So certainly if there is a situation where there is counterfeiting or some kind of infringement going on, certainly get in touch with the Canadian agent on the file. And I would encourage exploring and putting forward a request for expedited examination in those cases, because you could be really bringing your wait time down from a couple of years to literally a couple of days.
That's a great point, Kwan. And the basis on which you can request expedited examination, there are currently only a few bases: anticipated litigation, issues with online counterfeiting. If, for example, the applicant wishes to record its registered trademark with customs, for example, to stop the importation of counterfeit goods, that's another basis that can be cited. And I imagine that we'll see an increase in use of these requests as business moves online and brand owners realize that this can in fact work. If you fall into one of these few buckets, you can have your application examined very, very quickly. I should also mention that Madrid applications may be examined or should be examined within 18 months of their filing. So that is another sort of way around these years-long wait times at the Trademarks Office. So if you're hell-bent on getting your registration as soon as possible, that's another avenue.
That's great. That's an excellent point. Thanks, Graham. So I think that brings us to the end of our questions for today, and I see that we're 2 minutes before time. So Graham, I'll turn it to you to wrap us up for today.
Well, thank you very much, Kwan. So we greatly appreciate everyone attending today's webinar. If there are any follow-up questions, please feel free to send them to us by email. We'd be happy to address them. And we thank you for taking the time for joining us today. And hopefully we'll see you next month, August 19th, for the next installment of our webinar series entitled Bricks to Clicks: Protecting Your Brand and Copyrights Online in Canada from Trolls to Counterfeiters and Media Pirates. Thank you all very much for joining us. Enjoy the afternoon. Take care. Bye-bye.